Hey everyone, Harry here to talk about the Supreme Court's really important decision in a case called Moore versus Harper that will certainly now be overshadowed by the humongous decision in the affirmative action cases, which are the cases that this term will be known for. But a couple days before that, they issued Moore versus Harper in the so-called independent state legislature doctrine. Or theory, whether doctrine or theory, nobody had heard of it before a few years ago. But it kind of attempts to make a law out of what had been a pretty wacky opinion by Chief Justice Rehnquist in the madcap, final hours as they were fixing to essentially decide the election for George W. Bush. And Rehnquist suggested for two people on the court that there is a mention of state legislatures in the Constitution. They have the power to decide the time, place, and manner of choosing electors, the people who actually, vote in the electoral college, the very people that Trump and company are accused of trying to falsify in this last go-round. But it mentions them, so Rehnquist says that gives them special elevated status, and the argument went. They can decide, have final authority over who are the electors. They can take a 60-40 decision in the popular vote for Biden, say, and just declare, because they're the state legislature and they're mentioned in the federal Constitution, our electors are for Trump. So just a completely anti-democratic, totally Trump, as it were, what the popular will says. A very convenient theory, among other things, for Republicans who tend to have their biggest political domination at the level of individual state legislatures, and one that could have been in combination with, say, Trump wanting in 2024, losing and trying to pull the same kind of anti-democratic reversal as he did in 2020. If the court had endorsed this theory, it really could have happened. It would just have been up to the state legislatures. Okay, the court didn't endorse the theory, very much didn't endorse the theory, and an opinion by Chief Justice Roberts for 6 members of the court said, this makes no sense. And it's kind of an interesting angle because Roberts actually clerked for Rehnquist, so he's kind of slaying the his judicial father or whatever, putting an end to this idea. And he did it for exactly the reasons that had been urged by the Department of Justice at the argument, and seem absolutely right to me. And that is, look, state legislatures are creatures of state law. They come into being by a state constitution, and a state constitution automatically, inherently limits their powers according to state law. And just as in federal law, it's the courts under Marbury versus Madison who have the authority to say what the law is, the ultimate authority. Likewise in states, that's what state courts do. So if a legislature declares something cockamamie, that has to be subject to the state court's ability to say, no, that doesn't accord with our fundamental law. Otherwise, basically, the federal Constitution would be throwing out the very notion of a rule of law where federal elections, this would have been just for federal elections, because that's what the Constitution speaks to. They would have been just able to throw it out and have the rawest kind of politics control. Now, the case, there was an expectation that maybe they wouldn't reach the merits in the case. That would have been the easy way out, because after they took the case, the North Carolina Supreme Court changed its composition, kind of ironically, got, instead of the mixed court that had struck down what the legislature had done, was an all Republican or lopsidedly Republican court that had changed and more or less approved, and the Supreme Court could have said, so this case is now moot, or it's we send it back because the basic facts have changed so much. And Justice Thomas, in dissent, said that's exactly what they should have done. And so it's doubly, I think, noteworthy that Roberts didn't buy into that and took the occasion to really put the sword to this idea and just basically really excise it from the notion of any kind of legal legitimacy. So, in very kind of fundamental terms, he, joined by the other 5 members, say, you can't. There's no such thing as this law-free court, insulated from all judicial review, legislative action. The whole notion of what legislatures do, as they actually come to being in their charter documents, inherently means they're limited by state courts. So the specter that we might have had of legislatures totally imposing their will for the rawest and most partisan and maybe even racial reasons, because so many of these gerrymandered maps try to limit the impact of minority voters in the state. That notion would have been a revolution in federal elections. That revolution won't happen. It's been tamped down definitively by what you have to call either a liberal or certainly the preferred progressive result, just for good government, by the Supreme Court, emphatically accepted and adopted by the Chief Justice of the United States' first 6 members. There you have it. No more independent state legislature theory, except in the minds of, say, John Eastman, and future academic discourses, but not in the Supreme Court, and not in the state legislatures, and not in the 2024 election and going forward. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.